Okay, we're now open for attendees to start joining the room. So we have the cover slide for today's presentation up on the screen. People are starting to pop in, so welcome. We will get started right at the scheduled time in just a few minutes. Again, you should be able to see the cover slide from the slide presentation. You should be able to access a chat window. And we will get started in just a couple of minutes. Make sure you know where the chat function is, because that's how you're going to ask questions for the Q&A at the end. I'll go over that again as we get started. So just a couple more minutes here. We will get started with the presentation. I'm Scott Horton. I'll be presenting along with Julie Bastian today. We'll give the full intro momentarily when we get started, but we still have a few more people that are signing in. Welcome again, everyone who has logged in. We're still going to allow another minute or two for everyone else to get signed in, and then we will get started with the presentation. Okay, this will be the 1 minute warning. We'll get started with our presentation. A couple of people are still popping up into the room, so just want to make sure we start on time. Oh, I like that comment. Thank you, Margie, for letting us know you like the newsletters and webinars. We appreciate that. I will actually have more on that towards the end, just to remind everyone to get signed up for the newsletter, and if nothing else, so that you continue to find out about these webinars. All right, it looks like a good number of the people that registered are in the room. I'm sure a few more will continue to sign on, but I'm going to go ahead and get started. Today's presentation, Employment Law for the Holidays, Deck the Halls with HR Compliance, is presented by myself, Scott Horton. I am the founder and attorney with Horton Law PLLC. Julie Bastian, another attorney with the firm, is also presenting with me. Julie, do you want to say hi to everyone? Julie, you're there? Just check your mic.
Hello, can you hear me?
Yep.
Okay, good afternoon, everyone.
All right, so you'll hear from Julie in a few minutes. I'm going to go ahead with a few of the details for the presentation. First, to let you know that the slides that we're using in the presentation will be available for you after the fact, so I'll have a link at the end of the presentation so you can access those for your records. If you do want to ask any questions, we'll have question and answer at the end. We try to keep this to about an hour, but we will ask questions as long as they're coming in. and you can ask the questions in the chat room at any time, but we will probably hold off until the end to answer most of those, so I don't want you to forget what you need to ask. The other note on the questions and generally for the presentation is we can't provide specific legal advice to any of you in this webinar. We will be providing information that will probably be helpful to you, but if you have any specific situations, you can ask questions about them, but remember that other people will see your questions and hear the answers, so there will be no attorney-client privilege and it won't be entirely confidential. So you can always follow up afterward to ask us your specific questions, but any questions of a somewhat general nature that might help the group, we will look forward to answering at the end. With that, I'm going to get started. We thought this would be a good topic. We get a lot of questions about these issues as this time of year rolls around. We have Thanksgiving coming up in a couple of days now, and I want to wish everyone a happy Thanksgiving. And then, of course, we have the winter holidays, Hanukkah, Christmas, and others coming up with the year end and New Year's. And what we're going to do is talk about some of the issues that come up with those holidays and around this time of year, but a lot of what we're going to discuss would be applicable for other situations that you might deal with throughout the year as well. This is just a convenient way to put all that information together regarding the holiday season, but you'll be able to extract some useful information that will be relevant to year-round as well. So here are the topics that we're going to specifically go into more detail: holiday parties, religious issues, attendance and weather circumstances, and holiday bonuses. And again, some of what we're going to talk about would apply if you're going to have a summer party, for example, or summer social gathering, as well as holiday parties. Religion issues could come up at any time of the year. Weather issues and attendance issues and bonuses are all year-round potential compliance situations, but they all tend to really be prevalent during the holidays. So first of all, we have our holiday parties that some people enjoy going to, other people see as more of a chore, and some companies decide to have them, some don't for various reasons, some financial, some out of concern of legal risks. So we're going to start by going over some of that as far as why you might have a holiday party. Again, be a time to celebrate potentially your employees, their accomplishments, business success, that type of thing towards the end of the year. Show employees your appreciation for their service throughout the year. Rewarding them in a way, whether just by having the party itself or perhaps actually giving awards to employees, your Employee of the Year award or your attendance awards. You could do it obviously at any point, but sometimes companies like to do it at the holiday party because they have the company all together and it tends to be near the end of the year anyway. You can add different components to your holiday party. You might have speeches, you might have presentations, etc. So there's really no rules on what a holiday party looks like. We're really talking about parties that happen to coincide around the holidays in particular, but you could equally, again, you apply much of this information to any sort of social gathering with the company throughout the year. I want to just go ahead and make this a little bit interactive and ask how many of you are going to have a holiday party in your organization this year. Just for curiosity, this will be anonymous, but we can see generally who is and who isn't in terms of raw numbers. So if you'll just click yes or no, or don't know if you're either undecided or no one has told you. So far, looks like over 70%, maybe 3/4 of the audience will be having a holiday party. Less than 1 out of 5 won't be, and about 10% don't know. So it's still the overwhelming majority of your workplaces, it sounds like, will be having some form of holiday party this year, which is not surprising. I think if anything, there probably is a trend away from holiday parties, or in other cases, a trend to sort of downside the holiday party for various reasons. But many companies still have a full blown holiday party outside of work for dinner. So then there is the question of what does a holiday party look like? It can take a lot of forms. First question is we kind of just discussed through the poll is, should you have a holiday party? And if you decide you want to, you have to address additional questions like, is it going to be during or after work? Will it be on site or in an outside venue? Are you just going to invite employees, or are you going to invite spouses and guests, the +1 invite, for example? Are you going to open it up to children, or is this just going to be for adults? And a lot of these decisions will depend on your workforce, your work facilities. If you have a venue on site to have the party, that might be a good choice. There might be reasons that you don't want to do it at the office. And then that would also play into whether you're going to do it at work or outside of work. You might have a conference room where you can bring everyone in there. You might do it at lunchtime. You might just have a small mid-afternoon gathering. Then that leads me to the next question. Are you going to have alcohol involved? If so, are you just going to give everybody a beer or pour everyone a glass of wine or champagne? Or are you going to have more open bar alcohol, like various liquors? Might have specialty drinks, eggnog for the holidays, for example. So there's all these decisions that have to be made going into structuring your holiday party. Many of you probably just do what you did last year, and some companies have been doing more or less the same thing for many years, but a lot of other companies decide every year how they're going to approach it. Again, maybe it's what's left in the budget for the year, or we had some things that went wrong last year, so what are we going to change this time around? Some of the things that can go wrong. Obviously, the last couple of years, there's been a lot of emphasis and awareness around sexual harassment. That is something that can happen at holiday parties just like it can throughout the year, but there might be reasons why it becomes a little more common at a holiday party, a social event where people are maybe a little more relaxed than they normally are during their work day. There might be alcohol involved that helps with the relaxation or relaxing, some inhibitions, if you will. That's not just going to lead to things like sexual harassment. It could also result in bullying. People might become more argumentative. Alcohol, for example, has different effects on different people, and depending on what and how much they drink, it could just lead to sort of hijinks. So this misconduct category we put on here, is somebody going to think it's funny to pull a prank on someone at the holiday party, whatever that might be? Anything from, knocking over the Christmas tree just for laughs to, hiding someone company present or award that they got. I mean, all sorts of more imaginative things in between. There could be accidents, of course. One concern, especially with alcohol, is what happens if employees get into car accidents on their way home from the party. In some situations, that might produce potential liability for the company. That can also be a factor in whether you host the event on site or at an outside venue, whether it be through car accidents or just people behaving a little freely at a holiday party. Even if it's just dancing, there could be physical injury, which might mean workers' comp claims, for example. And of course, intoxication itself is a concern, which might lead to any of these other problems, but might just lead toward making people sick and behave in ways that they shouldn't behave. There might also be the consideration of employees who don't drink or might be either alcoholics or attempting to keep themselves sober, but if they're placed in a party where there's alcohol involved, what issues does that create? So all sorts of potential headaches, unfortunately, for holiday parties, and in some respects, they might be exacerbated from what you might confront from a normal day-to-day business standpoint. But again, any of these things can pop up throughout the year, connected to the workplace as well. So with all that said, I'm going to now turn it over to Julie to try to shed some light on how to minimize the risks associated with holiday parties. Julie, are you muted?
Hold on. Can you hear me now? Scott, can
Now
you hear me now?
I can now.
Oh, okay. All right. We'll start that over again. Sorry about that. Okay, so basically what we're going to try to do today is go over some of the ways in which employers can minimize the risk associated with some of the holiday party activities, whether it be a small party that they have on site at their work location or an event that they hold off site at, say, a restaurant. Some of these risks, one of them, which is a big one, and it's sort of controversial, is whether or not you eliminate or reduce the use of alcohol at these parties. I know typically whenever you have a holiday party, you tend to see more often alcohol at the party, but what more and more employers are finding out is, having that alcohol is leading to more issues, kind of the same issues that Scott had addressed for us earlier. One thing is you want to make sure that the attendance at the holiday party is voluntary. It's holiday. We talk about, some religious things that occur. You just want to make sure that it's not mandatory. If they want to attend the party, that's great. If they don't want to attend the party, that's fine. You encourage them to attend it, but let's make sure that you always make sure that every employee understands that attendance is voluntary. If you're going to serve alcohol, and you can't avoid it altogether, one recommendation is that you limit it to beer and wine and avoid the sort of hard liquor. It just seems to minimize the number of problems that you have with intoxication. It doesn't eliminate it altogether, but it of course minimizes it. And a lot of people don't like beer or wine, so you're going to cut down on the number of people who are drinking to begin with. One question is whether or not you schedule the party during the lunch hour or at a dinner hour or late at night. Believe it or not, this has a huge impact on reducing the risk. If you do it during a lunch hour, people are less likely to to get intoxicated because, once they leave the party, they still have other things to do with their families or, appointments, things like that, where if you schedule it as a dinner or a late night event, it tends to, you know, it tends to go on all night long. And so you want to make sure that you're controlling the behavior of your employees. If possible, and this is of course whether or not there's money in the budget, you want to allow employees to bring their spouses or a guest or even children. And of course that depends on the nature of the party and the venue. I mean, if you're going to have it at a bar, obviously you're not going to bring your children there, but studies show that if you tend to have your spouse with you or another guest with you, um, you see a reduced amount of, sexual harassment or intoxication. So that's something you want to think about. Um, the next one would be, before the party, providing each employee with a reminder of the important company rules that apply for the event. Those sexual harassment policies, whether or not it's appropriate to be intoxicated in a professional setting, things like that. Those things should be already included in your company handbook. But if for whatever reason they're not, it's something that you want to just make sure that you pull them out again and sort of remind people of those important policies. And for those individuals who just really aren't going to follow the rules, you want to make sure you have a backup plan. You want to arrange for rides home, whether it be through Uber, Lyft, taxi, shuttle, or even, sometimes you have a manager that's in charge of sort of a project manager that's in charge of just paying attention to, what's kind of going on at the party and making sure that there's no one leaving that is intoxicated. It's a huge risk for employers if you have them at a holiday party and they are intoxicated and they leave, and for whatever reason they do get into an accident and injure themselves or someone else. So it's definitely something that you want to pay attention to.
Julie, can I just
Yep,
add something real quick?
absolutely.
So I just want to kind of throw out the point that obviously we're talking about a lot of trade-offs here. You certainly risk upsetting people by your decisions in some of
Yeah.
these regards. Some people would rather have more alcohol than less, more variety than less. Some people would prefer to bring their spouses and or children. Other people would prefer not to bring their spouses and or children. If we're being entirely honest, some spouses would rather not be invited for various reasons. So again, this is not a playbook for how to run the perfect holiday party. This is just, the ways that you can try to make subtle improvement on your risk exposure, as you go through it. But you'll have to obviously weigh your circumstances and what's expected, what's required, who you have to make happy, and what you can tolerate.
And that's how I was putting together this presentation. Something that I did see was there was a lot of companies now that are putting together almost a project group that are, actually asking some of the employees what are the most important things that they see in a holiday party, and what are the things that, where would you like it to be? Is alcohol important to you? A lot of companies are moving towards going to, like a Dave and Buster's or something like a more of a group event, instead of something that's focused just around alcohol. So just throwing it out there. Okay. And then, okay. And then, of course, we have religious issues this time of year. Well, all year long, but this time of year in particular, we have a lot of religious issues that come up. The first one would be sorry, next slide. um, would be holiday decorations. Now, it obviously depends on the type of work environment that you have. Are you in a warehouse environment? Are you in an office environment? Um, but if your company is going to elect to allow people to decorate for the holidays, or permit employees to decorate their own work areas, we just have to be mindful that, there are a bunch of different religions, so you can't relate it to one specific holiday or religion. So, if it's traditionally a Christian religion, that you have majority of your employees that are Christian, then you want to make sure that you're being mindful of that one person that wants to put a menorah up or something like that. So you can't discriminate against those employees that have the those religions that are less frequent, I guess, in the office environment. So either you don't allow the decorating at all, or if you're going to allow the decorating, you're going to make sure that you allow it for any religion. Okay, next one would be protected religions and practices. So this is where it gets a little funky. Under the EEOC, we have traditional organized religions such as Christianity, Judaism, Islam, Hindu, and Buddhism. But we also have religious beliefs that are new or uncommon, not actually part of a formal church or sect. A lot of employers unfortunately believe that if it doesn't fall into one of those bigger religions, that it's not protected, and that's not the case. If you have a religion or a religious practice that's held by only a small number of followers, you still have to make sure that you're going through the same analysis to determine whether or not it's a protected, if they fall under a protected status. So just be mindful of that. If you do have something that comes up that is a little different, I should say, and you're not sure, that's when you want to call us and ask questions. Um, there are practices that might be protected under one religion that aren't protected under another religion. Example of that is, in some religions you shouldn't be working on a Saturday or Sunday. In other religions, it doesn't really matter. So when you have somebody who has a shift that's mandatory on a Saturday or Sunday, and you have an individual who comes and asks for religious accommodation to have off on a Saturday or a Sunday, it's definitely something that you should have a conversation about. Religious beliefs must be sincerely held, but it's often difficult and risky for employers to challenge this. So this whole area of religious protection is a risky one, because it's so easy for people to say that they fall under a protected religion, and you really got to do some research when you do have a religious request come in. And I don't know, Scott, in your experience, do you have any other examples of something that you have run across?
I mean, there's various other religious practices that come up, but as far as the holiday times go, I mean, one thing that we've been saying without discussing it is the holiday party, for example. We're
Yep,
not calling them Christmas parties anymore. There are people who are offended by that both ways.
yep,
There are
definitely.
people who are offended that it's not called a Christmas party, and there are people who get offended when it is called a Christmas party. So the best approach generally seems to be to call it a holiday party and
Yep,
acknowledge that it's not, you're seldom holding the party on Christmas, for
yeah,
example. So in that sense, I think you can use that to explain why you're not calling it a Christmas party if you need to. You really could call it a year-end party. You don't have to call it a
that's true.
holiday party. So that was just the one thing that jumped out to me at this point, as we've been kind of saying holiday party without further discussion.
Okay. Right. Next one are reasonable accommodations. And so we have limited inquiries on validity or of belief. You want to make sure that when somebody is making a reasonable accommodation request, especially when it comes to a religious accommodation, you're really looking at that request, making sure it falls under a valid religion and it's a reasonable belief or practice under that religion. Some accommodation requests that we see a time off request, schedule change, or workplace adjustments. The same kind of rules apply. Is it an undue hardship? Is the religious accommodation that's being requested by the employee, does it pose an undue hardship on the employer? One thing to note is it's very difficult for an employer to show that it poses an undue hardship on them for an accommodation request, especially when it comes to a religious request. You'd have to show that it's really expensive to the organization in order to implement that accommodation. It compromises workplace safety or efficiency. It infringes upon the rights of another employee, or it actually makes other employees incur more responsibility or potentially hazardous or burdensome work. It's really a case-by-case analysis, and whether or not you're placing an undue hardship on that employer. Like I said, it's very challenging for an employer to show that. There is no legal requirement to compensate employees for time off for religious observance, including holidays, unless, of course, they're provided by a company agreement or policy or collective bargaining agreement. This is hard for many employees to understand. Coming from a staffing industry, it's very hard for people to understand that holidays, you don't automatically get a holiday off, and when you do get a holiday off, or when you're required to work on a holiday, it doesn't automatically mean that you get premium compensation or time and a half for hours worked on those days. So it is important for employers to know that there is no legal requirement, at least in New York, for people to be compensated for time off on those religious holidays. Okay. Undue hardship, we kind of talked about a little before. It's a religious accommodation request that is considered burdensome or involves an excessive cost to the employer. A request that substantially harms employee morale, reduces efficiencies in other jobs, or infringes upon the rights of other workers. An accommodation that causes a safety concern for the employee or coworkers. Like I said, it's really hard for an employer to show that there is an undue hardship for an accommodation request, especially when you've got a company that has, say, 10 individuals working in the same job or the same position. So if somebody asks for a schedule change, yeah, I can't work on Saturdays, it's very easy to shift around some schedules to make sure that one individual has off on that Saturday. Actually, I don't know okay. Accommodation examples, just some examples that we see. An exception to the company dress or grooming policy, whether it be, I think we just recently had, changes to the policy, whether or not it's, grooming with your hair or your religious beard, things like that, or whether it be you can't wear hats or scarves, schedule change requests to attend church services on certain days, accommodation for, this is a different one, accommodation for an atheist to be excused from any religious practices that may be observed at the beginning of a staff meeting. Sometimes we forget about these things. And then another example would be a pharmacist who's excused from filling prescriptions for birth control based on their own religious beliefs. All right. And then best practices, some best practices that we have. The biggest one is maintain a written policy that addresses religious accommodation requests. If your company doesn't know how to handle these requests, that's all the way from your executive staff, your HR staff, and then your day-to-day staff. They need to understand how to make a religious request, and then what religious requests are granted, and what the procedure is. Establish consistent procedures for making and handling those requests. Make sure that you're not discriminating against certain religions or certain protected statuses. Require that whenever feasible, all time off must be requested in advance to allow adequate time to plan accordingly, and adjust work schedules whenever necessary. This is actually, it's a fair request for employers. I mean, we have to make sure that we all have a job to do. We have to make sure that we have enough people to run the schedule, run the shift. If the accommodation requested causes a serious conflict for the employer, an alternative accommodation may be considered that would achieve the same or similar result. We can substitute employees, change work schedules, or allow for flex schedules. This is sometimes difficult for employers. A lot of times people think that you automatically have to grant the accommodation requested by the employee, but that's not necessarily always the case. If there's an accommodation out there, and this is similar for Americans with disabilities as well, if there's an accommodation out there that will give them the same, it will achieve the same concepts, and everybody will be happy in the situation, but it doesn't give them exactly what they want. You're allowed to have that interactive conversation with the employee and come up with something, an alternative that might be slightly different. Oh, and I think I'm going to turn this over to Scott.
Okay, thanks, Julie. So some of the issues with the religion kind of crossed over into attendance issues. So we're going to transition, so it might be a little bit of repetition right at the beginning here. For example, Julie already noted about holiday pay not being required, but I just want to have the separate information here for you. So again, the FLSA, that is the federal minimum wage and overtime law, does not count holiday pay as time worked for overtime eligibility. So even if you do pay employees either for the holiday when they don't work or additional time when they do work, that compensation and the hours that it represents does not count towards overtime eligibility under the FLSA. The same is true in New York, under New York law, where I think most of the audience is, but other state laws might vary occasionally in that respect. On the other hand, if you have a company policy or union contract that says otherwise, then you would have to follow that, especially in the unionized context. It's not unusual for union to negotiate where they have the right to be paid on holidays, maybe time and a half, maybe double time in some cases, or what have you. So I don't want to mislead you and say, oh, you don't have to follow that. If you've agreed to it, you have to follow it. If it's in your company policies, employee handbook, etc., you should be following it. But I just want to point out what's legally required. And that can also mean that that time under policy or agreement has to be included toward time worked for overtime. Again, can be a difference between what the law strictly requires and what you as a company have agreed to do. Exempt employees. So here it's important to note we're talking about salaried exempt employees that receive time off for holidays have to be paid their full weekly salary for any week in which they worked. In other words, take this week, Thanksgiving, if you have exempt salaried employees who get Thursday and Friday off, they still need to be paid the full salary for the week unless they're scheduled to work one of those days and don't show up under certain circumstances. Then they might not have to be paid, but we're talking about the situation where you give them the day off. So you can't deduct from their salary when the office is closed for the holiday. But if you don't have paid holidays or want to have a policy of not having paid holidays for your salaried employees, theoretically you could do that and require them to use personal or vacation time. But if they are out of personal or vacation time, you would then not be able to make a deduction from their pay. This is a pretty technical and complicated issue that probably doesn't come up that much. I doubt many companies are trying to deduct from salaried employees' pay for Thanksgiving, for example, but there might be other holidays where it's a different situation. So we wanted you to have that information. If the office is open, as I kind of alluded to a minute ago, exempt employees who just say, I'm not coming to work, whether allowed or against the employer's wishes, could have their salary reduced if they don't work the whole day. But that gets more complicated. If they call in sick, then you might not be able to make that deduction unless you have what the Department of Labor's consider a bona fide sick leave policy. So there's a little bit more detail than I want to cover in full here, but I wanted to note the issues. Also, you can generally have a policy requiring employees to work the day before and after a holiday in order to be received holiday pay. There's nothing legally problematic about that, as long as it's not inconsistent with an established company policy or agreement with the employees or a union if there is one, because again, you don't have to pay the holiday pay in the first place, so you can put whatever conditions you want on earning it. So we wanted to talk about weather-related absences. Obviously, severe weather can happen various times of the year, especially, we are in the Buffalo area here. Many of you listening are as well. The biggest weather-related consideration we have is the snow in the winter, or at least very cold weather and wintry conditions. So that happened to correlate with these winter holidays that we're primarily thinking of with regard to this presentation. But again, this can come into play at any time of the year. So again, under the Fair Labor Standards Act and many, if not all, state laws, you would not be required to compensate non-exempt employees for time missed as a result of inclement weather. In other words, if they can't make it in because of snow, then you don't have to pay them for missing that time. There are union contract, collective bargaining agreements that would require alternative compensation in that situation. Maybe they get paid for the whole day, maybe they get paid for part of the day, or maybe they have to get scheduled makeup time or something like that. But normally under the law, that's not required automatically. If the offices are open, again, related to what I talked about before, salaried exempt employees could have their salary reduced for a full day absence only, but if the employee comes in late, you cannot reduce their pay for a partial day absence if they're a salaried exempt employee. Again, most companies aren't bothering to go to that level of administrative hassle, for lack of a better word, anyway. But if you are in a company where you consider reducing salaried exempt employees' pay, you should be very careful because there are some pretty strict regulations on when you can and cannot do that. Again, for the exempt employees or even non-exempt employees, you could allow them to use up vacation or personal time to cover these absences when the office is open, or in the case of non-exempt employees, theoretically, even in the case of exempt employees, you could allow them to take personal or vacation time to cover days even when the office is closed if you're not otherwise paying them. Again, this is pretty technical. If you have specific questions, you're welcome to ask them. I just want to give you the general gist of it, and that way you will know to at least think about it and ask the question later when it comes up. Again, kind of already mentioned this, but there are times when the office might only be closed for part of the day. You might have to let people go home early because of an anticipated weather situation. Usually, you're only required to compensate the non-exempt employees for the hours they actually worked. In these situations, you're going to have to pay the salaried employees once they've worked part of the day. But the non-exempt employees, if they only work 4 hours, you don't have to necessarily pay them for the 4 hours they would have worked had they not had to go home early because the office or plant closed. There are some state laws that have, whether it be call-in or call it something else, types of pay provisions that require companies to pay non-exempt employees for at least a certain number of hours if they show up for a scheduled shift and are sent home early. New York has such a law, although it doesn't always come into play because of the way it's currently written. There have been efforts to extend and amend that law, and that might yet happen. So I don't want to get too far into the details of that, but know that you might need to check that. And again, we've talked about the exempt salaried employees. Again, once an employee that is salaried and exempt works any part of the week, you have to pay them for the full week unless they take full day absences. And if they take full day absences of their own volition, their pay could be deducted in some cases for that, or they could be required to take up their PTO or vacation time. Here's another special issue that could come up at any point of the year, but it frequently in some industries seems to correspond with the end of the year, the week between Christmas and New Year's. In many situations is a downtime for workplaces, so they can choose to furlough or lay off their employees, maybe for a week. In some industries it's longer. Again, like I said, it's not just limited to the winter holiday season. The employers, once they lay off employees or tell them that you're no longer going to be scheduled for certain days, they're not required to pay the non-exempt employees. You don't have to pay exempt salaried employees either if they're off for the full week, but if you let them work Monday and Tuesday and say we don't have any work for you Wednesday through Friday, so don't come in, you're still going to have to pay them for the full week. Important to note that this situation could trigger unemployment issues. So states vary on their unemployment laws. Again, most of you have at least some employees in New York State. There's a 7-day waiting period. So if you just close down for 1 week, your employees likely won't actually receive unemployment, but they could apply for it. If you have a longer furlough period, then your employees might actually receive unemployment benefits. There is also in New York and some other states a type of program where you could potentially work to, instead of laying people off entirely, limit their hours. In New York, it's called the shared work program. So if this is something you do for an extended period of time and you're looking to manage your unemployment insurance premiums, then you might look into the shared work program. And with that, I think I am turning it back over to Julie to talk about this fun issue of holiday bonuses, which
Mhm.
everyone likes to receive, but not everyone gets right in the application.
Okay. All right. So we've got these holiday bonuses. Can everyone hear me? Yep.
I can hear you, Julie. You're good. You were good. Now you're not. Now
Okay.
you're good.
All right. It's customary for many companies to provide bonuses to employees around the holidays. Usually we use that time to recognize employees for their accomplishments, the company's accomplishments. A lot of times if they'll be given at the beginning of the year certain metrics that they have to meet, and if they meet out those metrics, they're going to be paid out those bonuses at the end of the year. So I just wanted to give you some tips to remember when issuing those holiday bonuses. Those holiday bonuses are definitely subject to taxes. I know many employers don't often get this right, but they want to pay the most they can pay to the employee. So just we want to make sure that we're taking bonuses out of those taxes out of those holiday bonuses. Employers can categorize the bonus as a holiday bonus, but they should stay away from labeling it a Christmas bonus. And that's for all the reasons we talked about before. We want to make sure that we're staying away from labeling it certain religions. If we're paying it around certain holidays, let's just keep it entitled a holiday bonus and not any specific religion. A discretionary bonus is one in which the amount, eligibility, and timing of payment are left entirely up to the employer. It does not get applied toward the employee's regular rate of pay or get applied toward the calculation of overtime. Now, the difference between that and the discretionary bonus is that with non-discretionary bonus, they usually there's eligibility requirements associated with it. Usually has eligibility requirements associated with it and should be set forth in a written policy. So that's, when you're going to have those metric goals, those things that you have to meet in order to earn that goal. So non-discretionary bonuses must be included in the non-exempt employee's regular rate of pay and will impact overtime earned during the eligibility period for the bonus. So basically what happens is most holiday bonuses are considered a discretionary bonus. But unfortunately what happens is most employers treat them as non-discretionary bonuses, and they don't subject them to the regular rate of pay. That's something that's a little more complicated, and I don't know if we want to necessarily go into it for this webinar, but basically if you're going to give a holiday bonus that extends over the whole year, basically your performance over the whole year, and you're a non-exempt employee, you're going to have to actually go back and add that holiday bonus in the total compensation that person's earned over the whole year. And so if they've worked overtime, it increases the overtime rate that they've earned on each overtime hour that they've worked. I will tell you that there's a lot of employers that are not doing this correctly, probably don't even know that it exists. But we want to make sure if you are going to use a holiday bonus, if you have questions, you want to reach out to us, and we'll make sure that you're actually doing this correctly. I don't know if I missed anything. Kind of throwing it all out there at you, Scott. Did that come out correct?
Yeah, I think you're good. I mean, there's a lot of information on the slides here if it didn't. I mean, again, it's a complicated situation. We're just trying to raise the issue that it's something you might be wanting to think about, but you would need to dig in further if you have a specific concern in this area.
Yeah, so if you are going to use holiday bonuses, make sure that you are discussing it with somebody in the HR field, somebody in the legal field, and we'll make sure that you're taxing it right, and then you're also making sure that you're going back and factoring it into the non-exempt employees' overtime pay.
Let me just go to the really basic question. Be very careful about handing employees cash. So,
Oh, yeah.
if you want to give every employee $100 and you just hand them $100 cash, I mean, that is wages that need to be run through payroll and subjected to tax withholdings. If you want to give everybody, a $15 box of chocolate, that's not necessarily a taxable situation. But once you get much higher in value than that, even tangible gifts could have tax implications. So make sure you run all that through finance and check with, the accounting function you have for your organization before you just start doing that. And if what you want to do is give everybody $500 to actually spend, recognize that they're going to get taxed on that, and you would have to actually bump up the bonus beyond $500 so that the person actually nets out the $500.
Exactly. Okay. So discretionary versus non-discretionary. Discretionary is, that's where we're going to get the amount, the eligibility, and timing of payment are left entirely up to the employer. It's not applied toward the employee's regular rate of pay, and it doesn't affect the overtime calculation. The non-discretionary bonus usually has predetermined eligibility requirements and should be set forth in a written policy. Those are going to be loosely your commission agreements, your attendance policies, your production goals, your incentive payments, things that you want to make sure that you set out at the beginning of the employee's employment, and if they meet those metric goals, then you're going to be paying out that non-discretionary bonus at the end of the year, end of the quarter, whatever it may be in that written agreement. Those bonuses, those non-discretionary bonuses, must be included in the non-exempt employee's regular rate of pay, and they will impact the overtime rate earned during the period of eligibility. So if you set up a bonus structure where it says, okay, with the first 6 months, if you meet 100, I don't even know, if you create 100 widgets within the first 6 months, that's going to be that eligibility period, that's 6 months. So when determining whether or not you have to go back to modify overtime, you'd go back the 6 months. Many employers fail to include non-discretionary bonus in the regular rate of pay and do not go back and adjust the rate paid for overtime earned during that eligibility period. All right. Come on. All right. Now we've got, I think this is fine as well. So now we've got our holiday bonus trap here. Employers typically treat holiday bonuses as discretionary since they are not expressly guaranteed to the employee. I know a lot of employers say, oh, every year I'm going to give my employees a holiday bonus, but it's not guaranteed. It's not based on their performance. It's not based on any certain metrics, but it's basically, it depends on how well the company does, and I'm going to give them a bonus at the end of the year if they do well. Problem is, if the employer has a consistent practice of providing employees with the holiday bonus, the employees might rely upon the holiday bonus each year and consider the holiday bonus amount in their overall annual compensation. Thus, the bonus might no longer qualify as discretionary. If there appears to be a standard calculation used by the employer to determine the amount of the holiday bonus, it could be the employee's attendance, if they're often show up to work. It could be the performance, how well they do that year. Even though they say it's a discretionary bonus, you can tell when you break down the bonus amounts that it's based on the person's performance or attendance, and there is some kind of factors that are used to come up with that calculation. And because of that, it's considered a non-discretionary bonus, and it would be subject to the regular rate of pay and modification to overtime. So if someone were to file a claim and say, hey, I was really entitled to this bonus, this holiday bonus, and I didn't get it, unfortunately, in many cases, the employee would win. I don't know. So Scott, have you had examples of this in your practice? I know I have in your practice where somebody has made a claim that they were entitled to one of these holiday bonuses.
I mean, I have had it in the union context,
Mm,
especially where they can argue a past practice.
right.
So, you've given something out ranging from a ham to cash for however many years, and then you stop it. Again, the the Christmas ham versus a cash payment is probably a relevant distinction too. I mean, you're less likely to have somebody claim that the ham was wages that they have a claim to, but there are ways to manage it too. If you're always giving out a $500 Christmas bonus for however many years, and now you're not going to do it this year, you should probably notify your employees as soon as possible. I think a lot of us probably have seen National Lampoon's Christmas Vacation, where the father was expecting a generous Christmas bonus, and then I think he got a certificate to the Jelly of the Month Club or something like that at the end of the day, which wasn't going to pay for his new swimming pool that he'd been dreaming about. So,
Right.
it's one of those things. If you have to do it, then you should make a communication.
Right. I
Real
agree.
quick, yeah, yes, Margie, your questions are still here, and we will be answering them momentarily.
Okay. Um, and then, I think I'll turn this over to you, Scott.
Yeah, that's fine. So we're about through the presentation. We are going to answer these good questions that have been asked, and if you have more, keep typing them in. We had a mention earlier of our newsletter, so I do want to make sure if you are watching this and not already registered for our newsletter, please go and sign up. You can do that right on the website, hortonpllc.com. You can go to newsletter, sign up, or you can just go to the website itself and click contact us, and you can sign up for the newsletter there. We do send a free monthly email newsletter with lots of articles and updates, and we use that as well to give you the announcements of these webinars. We do the webinars almost monthly. Typically, it tends to be maybe 2 months out of 3 or 3 months out of 4, just to throw a break in there. This is probably the last webinar for 2019, but we'll certainly keep doing them in 2020. The other thing we encourage you to do is follow us if you are active on LinkedIn. We have a company page there where we are able to get out more updates more frequently. We send out the email newsletter monthly, but we post regularly on LinkedIn with updates as soon as we can. So we would definitely appreciate and encourage you to follow us there. You can find us on other forms of social media, but LinkedIn is the one that we most focus on getting the timely content out on. So with that, we are going to answer your questions. There have been several in, and I'm going to go through those and moderate answers between Julie and I. But real quick, I will put up the link to the slides, so you have that. So you should all now be able to click to get the slides. You will get an email as well tomorrow with also another link to download the slides if you don't feel like doing it right now. But if you want to have access soon, there's the way to do it. Now I want to go back. I'm going to probably go somewhat reverse order on these questions just because the later questions applied to what we talked about most recently. So one question that we had was, how about gift card from $100 plus? Can that be taxed? The actual answer to the question is that pretty much any gift card that the company gives to the employee is considered taxable income by the IRS. It just considers a gift card to be virtually the equivalent to cash, with the exception of de minimis amount of a gift that is specifically redeemable for a certain item. So if, for example, you wanted to give the Jelly of the Month Club or Christmas ham, but didn't want to be the one sending the jelly or delivering the hams, you might work out an arrangement where you give everybody a coupon to pick up a ham at a certain location from a certain, you know, butcher, for example, then that might not be taxable. But if you give just a general gift card that can be spent on pretty much whatever the employee desires, albeit subject to what that particular store might offer, it is probably a taxable gift. So, do people religiously track that and pay taxes on it? Check with your accounting department. But when you do, if they are following the IRS rules carefully, they will let you know that you would need to report that and pay taxes on it. Another question I wanted to try to tackle. So if New York non-exempt employees report to work and the office has to close early, does report-in pay need to be paid? So in New York, it's called call-in pay, and I kind of glossed over this because it gets a little complicated, but in most industries, the answer is probably yes and no. So technically, the New York requirement is that if you work less than 4 hours and your shift was longer than 4 hours because you're sent home, then you have to receive at least 4 hours of pay for the day at the minimum wage rate in New York, except that it's not measured on a daily basis, it's measured on a weekly basis. So as long as the employee makes enough total compensation for the week that when that call-in pay is factored in, they're still making more than the minimum wage for all of the hours that they worked in a week, you don't actually have to pay any additional compensation. So for the most part, the only time you would legally have to pay more under New York's wage laws would be the situation where somebody makes very close to minimum wage and or has a number of hours that they were cut short under 4 in a day where they were called in to work. So it also something that the Department of Labor tried to extend considerably, where my answer would have been totally different, but they proposed rules and then revoked them because they decided they probably didn't have the authority to go as far as they were going with their rules and now need to take it up as a legislative matter. So it is something that it is possible the New York legislature will amend by statute as early as 2020. If so, become much more burdensome on employers, but just how burdensome remains to be seen, and whether it happens in 2020 or some point going forward, it is likely to happen, and we'll just have to see how far they go. All right, where are we? So I think this is a question going back to the holiday parties, Julie. The question is, I get the voluntary status, but most employers have their bonuses distributed at that time, which changes the voluntary status. I don't know that necessarily most employers distribute bonuses at holiday parties, and maybe I'm missing the question, but I mean, there are certainly reasons why what you consider your holiday gathering, there might be reasons to want everybody there. So do you have any more thoughts on that?
Yeah, it's very clear. I mean, the research is very clear that you want to make sure that those holiday parties are voluntary and not mandatory. And if you do have a practice of handing out your holiday bonus at the party, my recommendation would be to hand them out before or after the party, and just specifically for those individuals. And because again, you don't want to link them to a specific religious holiday.
Yeah, I mean, I think in a lot of situations, what you want to do is draw a line between a business meeting and
Mm-hmm.
a party. I mean, if you want to have your annual office meeting at 4 o'clock and run till 5, do the business type items that you need to do, and then say, okay, we're going to take a 30-minute break or 10-minute break or 15-minute break. I mean, it doesn't really matter, but, and then we're going to have our holiday party for anyone who wants to stay around. That's an option. The voluntariness also certainly has implications for whether you have to pay employees to be there. Again, we're
That's
talking
true.
about hourly employees. So if you have a party where employees are essentially expected to be there, you better plan on paying them. There are situations where you will have employees who have to work or are working at the party, whether it be security or people that are cleaning up or people that are passing out the drink tickets or something like that. For the most part, those people are likely working and would be entitled to compensation um, for that. So there's some questions there or some considerations there. Another question we had is it true that a company can limit liability by having the event at a restaurant or another venue? Also, if you lease out a bartender from a restaurant or a service, does that reduce liability from DWI or other accidents? I mean, I think
No.
yeah, I mean, the answer is yes and no. It theoretically does, and if you do it right, in the sense that, if you are at an outside venue that has a liquor license and they're the ones responsible for um, distributing the alcohol to employees and then there's an accident after the fact, then yes, arguably that restaurant or bar becomes liable, but that doesn't mean that you're going to escape potential liability as a company. If you're really careful about these things, you probably have a written contract with the venue, in which case, possibly one party or the other could try to allocate the liability across the table, and there might be indemnification provisions and that type of thing. But I'm guessing if you just decide to go to the local restaurant and have a holiday party, you're probably not bothering to sign one of these agreements. And if you are, they're probably not going to be real excited about an indemnification provision where you say that anything that happens, to any of the people that are in attendance after they leave or while they're there is going to be solely the restaurant's responsibility. And they'd have to pay your attorney's fees to defend any claims and that sort of thing. The average restaurant's going to say thanks, but no thanks for your business. And I would say the same is probably true for leasing, quote unquote, leasing a bartender from a restaurant or a service. Be careful whether you're now bringing that person in as an employee versus an independent contractor. But as long as they're an independent contractor, really, I think the same thing applies. It might practically reduce your liability because you might have people serving drinks who theoretically are better trained to know when to stop serving someone. So in that sense, it might help versus, so and so from the HR department serving drinks who might not exactly be a professional at that. But again, unless you get some really strong contractual indemnification, you know, you, you're giving them somebody else to sue. Let's put it that way. But you're not absolutely stopping them from suing you.
I mean, the other thing you want to think about is, and nobody really wants to think about this, but if for whatever reason it's the employee that's involved in the injury, when they're driving, it's the family members that you're worried about, and they're not necessarily going after the restaurant. I mean, they're going to go after everybody in the chain. So
Yeah, I would say the general advice, honestly, is to do it at an outside venue, but I wouldn't do it for that reason
Right.
where you think you're now going to be absolved of any responsibility. Again, it's some of the more practical considerations. Yes, there might be somebody else who has some responsibilities, so hopefully they're helping do the right thing. And yes, they are used to serving alcohol where most of your organizations are not. So hopefully they're more adept at doing that safely. There's other
Hmm.
factors like their venue is set up for people to be um, socializing where your office may not be, and there might be dangerous
Right.
items in your facility that wouldn't be present in a restaurant. So there's all these types of things. There's also food issues. Can you safely preserve food and serve it in your office space versus the way your restaurant does it? So I think a lot of those factors combine together to support the going to an outside venue approach. But again, if what you're trying to do is avoid any possible legal responsibility, you'd have to have some really strong agreement with the vendor to feel super confident about that. I will double check. I don't think I've missed any questions. Oh yeah, I did. One Julie question that came up. Wouldn't being able to fill a prescription for birth control be considered an essential function of the job since often pharmacists work alone? What do you think about
Hmm.
that one?
Um, I think in situations where you have, uh, I think it's limited to situations where you have like a Catholic health um, type of organization where they really have a religious affiliation associated with their um, practice. I think that's the problem.
Well, I think that would be a situation where the entire pharmacy might not have to prescribe it. But I think, it could be a sliding scale. I mean, if you think of a drugstore that at any given time is likely to have multiple pharmacists on duty and they have somebody who has a very strong religious belief against birth control, I mean, ideally you wouldn't want to force that person to administer or, supply the birth control pills and somebody else could do it. But I think ultimately it would become a tricky analysis under the
Hmm.
undue hardship issue. But so I wouldn't put a bright line on it in that
Right.
respect. It was just kind of an interesting example where among the religious accommodations that we might think of, especially around the holidays, that wasn't one. So that's why we threw it in, just to say don't prejudge what may or may not be a religion accommodation situation because you never know what might come up. I'm going to go back through. I don't see any more questions, and we're, um, 15 minutes past our hour. So thanks for all of you who have stayed with us. If you do have more questions and want to hurry up and type them in, that's fine. Otherwise, here's all of our contact information on the screen. You can certainly follow up with us. Hopefully, there's something that you've gotten out of this presentation that will help you over the next month or so around the holiday. But again, it's also information that can be relevant in different ways throughout the year.
Okay.
So unless there's any last minute questions, and I don't see any, then we will wrap up and look forward to seeing you back for our webinars in 2020.
Perfect. Bye.
All right.
Thank you very much.
Bye, everybody. Thanks.
Bye. Thanks. Bye.